The president, the vice president, governors and deputy governors can be investigated. The report of the investigation may be sent to the House of Assembly or the National Assembly, as the case may be, or kept until the governor will be out of office, just like the case of Governor Yofai.
But why is there a restraining order from the court preventing the State Assembly from conducting?
With profound respect, no court has the power in Nigeria to restrain an anti-graft agency or the House of Assembly of a state not to carry out its constitutional or statutory duty of investigating the crime of corruption. And in the case of Awemi and the Inspector General of Police, decided in the year 2000, the Supreme Court made the point abundantly clear that while those who are covered by immunity cannot be arrested or investigated and prosecuted, they can be investigated while in office. Yeah. And that is the law in Nigeria today. Yeah.
All right, sir. Finally, sir, EFCC has been foot dragging as far as this investigation is concerned.
Which one?
EFCC.
Foot dragging on which one?
On the investigation of Governor Ganduje.
No, EFCC has not even touched it. But again, as I did suggest here, that is not the end of the matter. Civil society organizations or any concerned citizen can activate Section 52 of the Constitution by requesting the Chief Justice of Nigeria to appoint an independent counsel, just like they do in the US, you know, and then ask for an investigation. That is what Mr. Muela is doing in the US. It's allowed here, where our law allows it here, and I'm sure that's going to be done.
That order of court came not just as a shock, but as a reversal of what the Supreme Court has settled over 10 years ago. That occupants of executive offices, whether governor or presidents, as secured under Section 308 of the Constitution, do not enjoy immunity with respect to investigation. They enjoy immunity with respect to prosecution. And therefore, if we have made the progress, and we have seen over time that part of the challenge of nation building in Nigeria today has to do with the propensity with which state actors, particularly occupants of executive positions, undermine and abuse their offices, then it comes across to me, in particular, as a reversal of the progress already made and the deliberate, a deliberate attempt to undermine the collective effort put in process to secure that minimal layer. So I think that the concerned people of Kano State, particularly the State House of Assembly, should be able to take the next important step to vacate that order. Because as it were, in the absence of the Supreme Court judgment that I mentioned, you would find that the attitude of our court has always been to respect the separation of powers. And if in the process of the observance of separation of power, it has been well established that there is no ambiguity as to investigation and prosecution, then it's only a question of time and little effort before that order can be vacated, because as it were, it's not well founded in law, neither is it founded in logic and even morality.